When you're ready. Go ahead.
Okay. Good morning. Thank you for inviting me to speak today. My name is Samuel Chang, and I'm a second-year law student, the student body president of UC Hastings, and a student director on the Korean American Bar Association of Northern California. I'm also the 14th Circuit Governor and serve on the ABA Law Student Division Board of Governors, but I do not speak for or on behalf of the ABA or the Law Student Division. Today, I am testifying in my capacity as a California law student. I come to shed some light on how the decline of bar exam passage rates impact students. I receive comments and stories from ABA law student members in California. So what's important to law students? First, affordability of their education, and second, subsequent employment after graduation. The low bar passage rate exacerbates both. Simply put, no bar, no job. But this has an emotional impact too. Here's some words students around California have used to describe the bar passage rate today: traumatizing, demoralizing, terrifying, deflating, and devastating. It's not simply a mere inconvenience to not pass the bar. The bar exam period is long and expensive. Right after a grueling 3 years in law school, another grueling 3 months of no pay, mounting debts, and continuous studying accompanies these students as they prepare for the bar exam. So imagine missing the threshold by 0.7% like one of the students. This student felt disheartened that despite taking a commercial bar prep program, they could not pass and start their legal career. Or think of another student who lost a job offer at the public defender's office because they failed the bar. Subsequently, that student could no longer afford to live in the apartment they were in and had to move back home. Yet California students, because of their low bar passage rate, is not any worse than those from other jurisdictions. In 2012, California students from ABA-approved law schools passed the California bar 20% higher than those from out-of-state ABA-approved law schools. Last year, California students still passed 3.3% higher than those from out-of-state ABA-approved law schools. If the California bar passage is any indicator, the quality of California students is in fact higher than those of out-of-state students. Naturally, this frustrates many California law students. This frustration has consequences. Students may choose to instead practice in a different jurisdiction simply because they have a greater chance to pass the bar there. The high financial and career risk has prompted students to reconsider being in California. This means that California may lose lawyers simply because of a score. Many law students have written that they love California and they chose a California law school to practice here. But what's the point, they write, if they cannot pass the bar? Such a shift means less lawyers for the growing population of California, less lawyers to protect consumers, less lawyers for the state, less lawyers for legal aid. In having a higher threshold for bar passage, California stands to lose quality attorneys all because of the bar and stands to widen the so-called justice gap. Low bar passage rate means a greater chance of unemployment for another year. Not many law firms or organizations are willing to retain students who have failed the bar. No job means an inability to pay the loans. The low bar passage rate does not just end job opportunities, but it influences it. A school's low bar passage rate skews an employer against its students and may prevent students from receiving a job offer simply because their school's bar passage rate was low. The low bar passage rate by a school affects the reputation of that school and in turn all the graduates of that school. Even students would base in some manner the success of the school on bar passage. Simply put, a low bar passage erodes students' and employers' confidence in the school, irregardless of what that bar should mean. In turn, students feel that because of a low bar passage rate, they as students feel second rate. And so some students have expressed a lot of anxiety over a larger black hole of debt. Multiple retakes of the California bar exam mean more law students have to add to their already burdensome debt by paying again the $830 bar examination fee, not to mention that the interest is beginning to accrue on their law school debts. My analysis of the standard 509 forms of all 21 ABA-accredited law schools found a higher number than found in the white paper. On average, a student without any financial scholarship would accrue $226,851.71 in tuition and living expenses. On average, living expenses amount to be about 58.27% of what tuition is. However, even if we were to take into account that 67% of all law students receive some grants, the average debt would be $417, assuming that all students received the median grant of $22,363 for 3 years. But adding the $830 bar examination fee, $677 if not using a laptop, each time one takes the test, another $2,000 and more for bar prep, a few more thousands for living costs during that time, and that's considerably more than the $148,167 average salary a lawyer receives in California. But that's the salary for all lawyers, not entry lawyers. According to the National Association for Law Placement, an average salary for an entry-level lawyer in a public interest or a government entity ranges from $44,600 to $51,100. That means even if a public interest lawyer were to give up their entire salary to pay the loans, they would still not be able to pay off their law school of loans for more than 3 years. And then adding that, delaying a year to retake the bar only exacerbates that. But the cost can be even higher. Most law students still have outstanding undergraduate loans. Some students have placed their whole life on hold just to do law school. They worked hard to get jobs after graduation, but without the ability to pass the bar, they're left back in the place they started, only with a considerable amount of debt. But it's not just that. A low bar passage rate feeds into the predatory bar prep industry. The fact that top bar pass companies charge upward of $3,995 without publishing their bar passage rate is concerning. Even when a bar prep company does, there's no guarantee that one will pass the bar. For example, Demas, one of the 3 most popular bar prep companies, only had a 66% first-time pass rate in California and 77% pass rate for those who completed 75% of the course. But what are students supposed to do? Not take it? They take this financial gamble because A, everyone around them seems to be doing it. B, they're encouraged to do so. And C, they would rather put in money to increase their possibility of passing the bar. But this is parasitic upon law students. Bar passage companies, not law students, not the California public, benefit from a low bar passage rate. But as is, legal education also takes a hit from a low bar passage rate. Students become more worried about passing the bar than getting a job. Instead of taking clinics or legal work, they stay at school and take more bar courses. One student phrased it well, that the great irony to be a lawyer is that all I have to do is to be more unprepared for the actual job. Legal education was not made to teach the bar, but teach practical skills and experiences to be a lawyer. But the bar exam makes legal education all about being better test takers than better lawyers. The bar fails to test the competence of law students. One student wrote that, quote, "The skills of a great lawyer cannot be measured by a written exam." It is counterintuitive to teach to pass the bar, but not develop the skills to be an attorney. Students have made it clear that despite a diminishing bar passage rate, the last thing law school should do is throw the baby out with the bathwater and should continue instead to train lawyers and not just teach the bar. I've heard that the bar is a bar of competence. But if it is of competence, I hope you ponder this point. If U.S. Senator Kamala Harris, former Dean of Stanford Law School Kathleen Sullivan, and 2 California governors, Jerry Brown and Pete Wilson, could not pass on their first try, but were wildly successful as California's Attorney General, a top law school dean, and governors of our great state, what does that say of the bar? Indeed, a student pointed out that a time test where one is required to memorize rules in and pull them out of one's head in a timed environment is something that no competent attorney would ever do when representing a client. Another agrees, stating that the practice of law is not shotgun decision-making or racehorse exams. The white paper makes it clear. A lower threshold on the bar exam means a higher bar pass rate. But a lower threshold, as one student puts it, also means less students putting their life on hold for another 6 months to retake the bar, less students who are unable to pay back their loans, less students who are unable to be lawyers. A lower threshold on the bar exam will also be life-challenging. In response to failing the bar, a UC Hastings student committed suicide. So I ask, could this student have been here today if the state bar had lowered its threshold? Possibly. I leave you with this last quote. The UC Hastings dean wrote a letter soon after learning about the suicide of the student, writing, "This is not the only story we need to tell nor to hear. We need to hear that how we score on an exam is not the measure of our potential as a lawyer, much less our worth as a person." So in recent times, the public has realized the importance of lawyers. There are many good law students in California that can also just be as good as many good lawyers. And that starts with changing the arbitrary standards of the bar examination. And for that, I urge you to take action. Thank you.